Hey everyone, this is Brandon Bookout with my proposed policy for CJ5580 Crime and Public Policy. As you can see, my policy is aimed at addressing the innocence problem within plea bargaining by specifically abolishing the practice as a whole. Before we talk about the policy, it is important to understand where the innocence problem is within plea bargaining. Early history of plea bargaining, circa the United States Civil War, identifies that a large majority of the courts did not approve of the practice. Some courts viewed plea bargaining as incentivizing admissions of guilt, while others viewed the practice as coercing admissions of guilt. Either way, courts believed that plea bargaining was a strict violation of the defendant's due process rights. Present-day plea bargaining is utilized in roughly 90% of criminal cases, which leads to it contributing predominantly to the number of wrongful convictions each year in the United States. Criminologists have attempted to pinpoint the exact percentage of wrongful convictions in several different studies. However, most are only able to put it within a range of 2% to 8% of all individuals convicted of a crime being innocent in the United States. It's also important to understand how court actors can play a part in the innocence problem with plea bargaining. Prosecutors contribute to the issue as plea bargaining guarantees them a conviction without trial, and prosecutors also have no concern over defendant's culpability, but with attaining a conviction and fast-tracking cases off the docket. Prosecutors want to spend the least amount of time on a case as they can. With the defendant, the presentation of a plea bargain to a defendant can be phrased in such a manner that causes the defendant to believe it is a take it or leave it situation. Oftentimes, when a defendant is confronted with a plea negotiation, they believe that if they don't accept the plea negotiation right then and there, their only other option is a trial, which bears a stricter punishment. Plea bargaining also lowers the standard of proof from proof beyond a reasonable doubt, which is needed at trial, to only probable cause. This is because it only takes probable cause to bring charges up against a defendant. Plea bargaining increases the number of innocent persons found guilty because every person who pleads guilty is convicted, whereas only some portion of those who go to trial are convicted. Defense attorneys, specifically public defenders, have external incentives to plea negotiations that mainly stem from financial perspectives, they mainly stem from a financial perspective as they are typically paid a flat fee. Public defenders are motivated to encourage plea negotiations towards their defendants because they too want to reduce the amount of time spent on a single case. Public defenders do not get any extra pay for spending a large amount of time on a single case, and also they do have an overflowing workload under their belt, so they want to get as many cases disposed of as possible to reduce and manage that. Last contributor is organizational, as court dockets are continually overloaded, causing the judge and both the defense attorney and prosecution to have an unspoken understanding that they must process cases through the courts as efficiently as possible, being plea bargaining. Many courts are oftentimes overloaded with their docket, and it would be unsustainable for every case on the docket to go straight to trial. Therefore, plea bargaining is utilized to fast-track cases. The overall goal of the intervention is to reduce the number of wrongful convictions that are directly produced by plea negotiations, and also to strengthen the public's view of the justice system. The 27th Judicial District of Tennessee, covering Weakley and Obion County Circuit Courts, will be the affected district and will be studied for a duration of 5 years. The objectives of my study are to determine if the abolishing of plea negotiations will cause the district attorney's office to refine their screening protocol on cases they choose to pursue, to determine if abolishing plea bargaining will in turn cause the number of convictions in this district to be reduced, and to determine if abolishing plea bargaining will reduce the number of defendants who admit guilt instead of taking the case to trial. The study will collect relative data to measure and monitor the objectives detailed above from both courts during the 5 years of implementation, and they compare and contrast the same collected data to 5 years prior of implementation. This study will measure success of the policy by postulating a reduction in the number of defendants convicted each year and a reduction in the number of cases the prosecution pursues each year has correlation to a reduction of the number of wrongfully convicted individuals. For my intervention approach and policy design, convicted offenses will be collected and placed in broad categories, being violent crimes, drug crimes, and property crimes. Court personnel will remain the same, as any unnatural replacement of court personnel would potentially skew results. Research staff will be hired to collect data from the circuit court clerks and from interviews among the judge, prosecutors, and defense attorneys within the studied area. Additional staff will be placed with the district attorney's office to collect necessary data for the study, being how many cases the district attorney chooses to pursue, chooses not to pursue, and why. Those staff members that are collecting data will be labeled data collectors and will report monthly their data sets to their supervisor. Their supervisor will ensure the data collectors are adhering to their assigned roles and present the information and data collected to a committee of members that also meet monthly to discuss the results and other topics related to the study. Action planning. So funding, I plan to gain funding from the Office of Criminal Justice Programs under the Tennessee Department of Finance and Administration. The OCJP, it's an organization within the TDFA that is designed to specifically fund programs and studies that are aimed to make the criminal justice system more effective and address the issues with the criminal justice system. They allow for training, they allow for facilitation of the study, and a lot of other things, which would be very beneficial to the study if they were on board with providing funding. The Innocence Project would also be asked to fund, as the goal of the proposed policy is to reduce the number of innocent people convicted in the United States. So it's right up their alley with their goal. Also, the Tennessee Bar Association would be petitioned to provide funding. For a timeline, the study has a goal start date of July 1st, 2021, with an initiation of preliminary matters beginning August 1st, 2020. Preliminary matters are going to be your hiring of staff members, ensuring funding is secured, ensuring the area studied is good to go, training staff, and ensuring that staff knows or understands what the study is for and what their roles are. Once a research team is built and a committee is organized, meetings will be held monthly up to implementation and throughout the study. Before implementation, the monthly meetings are going to be to ensure everybody is on board with what the program is, or what the policy is aimed at finding, how it's going to be, and how it's going to be followed through. In addition to the monthly meetings, researchers will gather every 3 months to thoroughly evaluate the collected data and organize data into 4 parts every year. And then also, annual meetings will be held to further analyze data from the last year. Patterns and trends can be formulated along with discussion on other issues that have manifested during the study. So for policy implementation and monitoring, the data collection techniques, one is going to be service record collection. We're going to be working very closely with the court clerks, or the circuit court clerks, as they're going to have all the details and all the data that we need regarding each case that is disposed of in the assigned courts, and also observational data collection. We're going to interview and talk with our staff that are on the front line of implementation. We're going to do interviews with the judges, or with the judge, with the prosecution, and with the defense attorneys to understand their perspective and their belief on how the policy is playing out during implementation. Mechanisms for adjustment. Study length can be reduced for various reasons. If we don't have enough manpower to fund the study, if we don't have enough funding, we can reduce the study length from 5 years to 4 years to 3 years, however much it needs to be reduced. Target population can be refined. So right now the policy is aimed at studying every single defendant that goes through the Weakley and Obion County courts. It could be reduced to only drug offenses and drug offenders that come through the courts if needed. Also, the scale of the study can be condensed. Right now the study is aimed at monitoring 2 different courts, the Weakley Circuit Court and the Obion Circuit Court. We could reduce the scale to only looking at 1 court instead of both courts. Evaluation. The impact evaluation method is going to be how we're going to evaluate it, because we want to see the desired outcomes versus the actual outcomes. So did the policy create the outcomes that we desired? Yes or no? Did prosecutors pursue fewer cases than normal in response to the new policy? Were the number of defendants convicted fewer than years prior to the study? That's what we want to see. A cost effectiveness analysis will also be implemented to the evaluation process. This will aid criminal justice scholars in determining if the outcomes associated with limiting the plea bargaining practice are valuable enough to justify the cost. This also allows for comparison to other policy studies aimed to address the same issue of the innocence problem within the criminal justice system. The study and cost effectiveness analysis will aid future literature on the topic in identifying better or revised policies. After the research staff and team members analyze the collected data, the results and findings will be presented to the study committee, comprised of individuals from our external stakeholders, our funding organizations, and other interested parties. It is desired that the study and its findings be published in many respected criminal justice journals. It is also hopeful that our funding agencies and external stakeholders promote our study at conferences and other scholarly criminal justice events to maximize the exposure of the study and its findings. And to end the presentation, Sir William Blackstone once did say, "Better that 10 guilty persons escape than that 1 innocent person suffer." Thank you.